All right, guys. So in the Declaration of Independence, it says that we find these truths to be self-evident. And what that means to me is these things don't need no explanation. You don't need to explain your rights. They're natural rights. You don't need to explain them. They're self-evident. You have a mouth. Your mouth is for speaking. You have eyes. Your eyes for seeing. It's self-evident. That's what those are for. So are these rights. And believe it or not, there are people out there that don't know their rights. And it's not so self-evident for them either. But how do they find out their rights if someone isn't telling them, or someone doesn't tell them what their rights are? And yeah, what kind of sense does that make if someone's telling you what your rights are? If someone's telling you what your rights are, chances are those rights aren't going to be in favor of you. It's going to be in favor of them. And if these truths are self-evident, why are we having to explain them all the time? And guess what, guys? Those rights are unlimited, or nearly unlimited. And those rights are the supreme law. All right, guys, check this out. The Constitution and the laws of the United States, which shall be made in pursuant thereof, and all treaties made, or which shall be made under the authority of the United States, shall be the supreme law of the land. And the judges in every state shall be bound thereby. Now get this point right here. Anything is separated, and thing is capitalized. Anything in the Constitution or laws of the states to the contrary, notwithstanding. That's a legal term. Notwithstanding meaning it has no standing in law. So if there's a law contrary to the Constitution, is it lawful? No. It has no standing. It's notwithstanding. Who says so? The supreme law of the land. Article 6, Section 2 of the Constitution. Not only that, but Marbury versus Madison. Chief Justice John Marshall, his opinion was that for a secondary law to come in conflict with the supreme law would be illogical, for the supreme law would prevail. And that's Marbury versus Madison. And we know that those that would give up their rights for safety deserve neither. Now you would think that with safety laws there would be some kind of constitutionality to it, because it's for safety, right? Safety doesn't necessarily mean constitutional. It doesn't mean that there's a degree of constitutionality. There are no degrees of constitutionality. Either it's constitutional or it's not. And if it's not constitutional, then it's not law. Check this out. This is American Jurisprudence, 2nd edition, volume 16. We're in the constitutional chapter here. Constitutional law, section 193, part D. Effects of total or partial unconstitutionality of statutes. Now what it's telling you that about the degrees of constitutionality. And you go down here, and it's made it very simple. And you know, it's total unconstitutionality. That's it. Now let's look at section 194. Effects of determination of total unconstitutionality of legislation. This will blow your mind. The general rule is that an unconstitutional statute, whether federal or state, though having the form and name of law, is in reality no law. Alright guys, let me know how you like that presentation. that Section 94. There's way more in that. Section 94. It's gold. It's all gold. If you guys want to know more, let me know. You know, this is just a little something you know, that I use in my own life, and how, you know, the research that I've done, and
You're right, Donnie.
and this is how I stand on what I say and what I believe in, and and you know, it's right there in black and white, guys. Um, there's no arguing about it. It's there, and it says what it says, right? All right, guys. Appreciate it, and that was for the record.
In reality is no law, but is wholly void and ineffective for any purpose, since unconstitutionality dates from the time of enactment and not merely from the date of the decision so branding it. An unconstitutional law in legal contemplation is as inoperative as if it had never been passed and never existed.
Yeah, that seems pretty clear to me, guys. How about you?
Since an unconstitutional law is void, it follows that generally the statute imposes no duties, confers no rights, creates no office or liabilities, bestows no power or authority on anyone, affords no protection, is incapable of creating rights or obligations. Keep up with me. A contract that rests on an unconstitutional statute creates no obligation to be impaired by subsequent legislation. No one is bound to obey an unconstitutional law, and no courts are bound to enforce it. A law contrary to the United States may not be enforced. Thank you, guys. Thank you. Stop. No, stop. Thank you, everyone. Thank you. You're embarrassing me, guys. Stop it, please, man. I was just kidding. Go ahead.